The IP value pendulum. Did your patents just become more valuable? Greetings. Hello and welcome back to Invent Anything. In this episode, we'll talk about how the IP value pendulum has swung back towards stronger patents and what this means for your IP strategy. We'll hit things like the short history of IP value, generic IP value methods, litigation, inter partes review relief, and new thinking for patent owners, as well as the future for AI-driven patent litigation. This is John Cronin from Invent Anything.
Inventions keep the world spinning. From fire in the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
Today we're going to cover 6 different topics. The first topic is topic number 1, a short history of IP value. Once we've done this, we'll then talk about the generic methods for IP value, something we all need to keep in mind in terms of how value is created with IP. Then we'll talk about litigation and the general pressure that litigation has caused and how that may have changed. But then we move to the new news, the inter partes review relief and administration changes in the Patent Office and how that changes everything as early as last week. We'll talk about the new thinking for patent owners that this now means because of the inter partes review change. And then we'll talk about what this all means for the future of litigation with AI. And then we'll wrap up. Now, generally for each podcast I think about the audience, and it's interesting. The audience here could be for CEOs who want to understand why patent value is rising again, and why does that maybe have to do with them needing to build an IP portfolio now. Maybe they didn't have in the past. We'll talk about product leaders, how IP shapes roadmaps for defensibility now, because patents are stronger. We'll talk about inventors, why patents are more enforceable. That's very good news. We'll talk about investors. They may see a total ROI shift of their companies that are IP backed. Maybe they'll be asking for more IP development. And for marketers, patents will increase the product trust. And this is really good against copycats. So the patents can stop copycats much better than they could in the past. And then for legal counsel, they're going to be adjusting to the new inter partes review standards, meaning that I think they're going to have to start thinking more and more like litigators now. We're going to unpack all the short history of IP value from guild secrecy, showing that where it all started in Venice, talk about Carnegie and Bessemer Steel, talk about all sorts of different companies that have changed the value of IP over time. And then we'll talk about generic methods for IP value, from large cross-licensing of portfolios to patent plus trade secret fences, inventing around continuations, formal IP valuations, and also AI-enabled stories. So coming up, and stay tuned. So in the first topic, let's talk about the short history of IP value. A lot of people don't know the history of the patent system, but that's okay. But I'd like to show it through the lens of value. Basically, the patent system really started in the medieval times in the guilds, where basically, if you wanted to be mighty, you had an army. And then as you wanted to be stronger, you had an army and you had lots of money. But as those two concepts of power and might came about, something happened to try to keep the kingdoms of people, in your feudal system kingdom, and that is that the guilds got developed so that people could get, some stronger, benefit for being innovative. So if they made shoes, for instance, they could join a shoe guild, and by doing that, they got higher prices for their shoes, but also they had more of an exclusivity. Then in about 1474, Sicily started with an early sort of patent system, which then allowed some limited time of exclusivity for ideas. If you were a glassmaker, for instance, you could register the new technique and you get 10 years of sort of exclusivity. And then in the United States in the 1790s, generated the Patent Act, which was the first patent office, and basically got it more formalized by 1836 with the Office of Patent Examination. Even Britain followed suit in the 1850s with the Patent Law Amendment Act. So now, as these patent systems gets rolling, the U.S. being the first, it turns out that we started, taking a look at, what the patent system was doing. Even the first patent in the United States, which was by a Vermonter on potash, a way of making soap. I mean, if you take a look at these patents, they were just one page with a paragraph of the person that owned it and what they thought they owned. But today it's much more formalized. And so we see that very early on, it was just like a paragraph or two. Today, in fact, there's many regulations and ways that these patents are being drafted. Then what happened in the 1800s was that basically patents were really well respected. If you got a patent, that was a badge of honor. And there are all sorts of stories like Andrew Carnegie going across the entire country to see Bessemer to get access to the Bessemer steel patents. Think about that. Andrew Carnegie, the richest guy in the world, basically, went out of his way to try to get the license agreement to Bessemer Steel. That showed you the huge amounts of respect. Then the world changed for patents. Farnsworth, a young lad of 14, 15, invented the television. And then he got patents on it and generated a lot of investment money as he got older to build one. RCA, basically Sarnoff running RCA, got very worried that they were selling radios and that the radios may go out of fashion and give way to televisions. And so what happened is that RCA did something very interesting to the patent system. They hired a bunch of engineers and lawyers and just sat around inventing on top of Farnsworth, to the point that they developed so many patents that Farnsworth needed RCA as well as RCA needed Farnsworth. Who do you think won that battle? Farnsworth, as I understand it, died penniless and very upset that his invention was sort of taken over by RCA. Then this sort of whole patent system started motoring to the 1940s to the 1960s, 1965. The U.S. was the patent system, but also the U.S. had huge amounts of R&D and technology. After World War II, the U.S. was leading almost every single industry. Big companies and universities really ruled on getting patents. Then what happened after World War II is that in all sorts of industries beyond the universities and large companies started to pop up, and patents became more important. I lived through this, and early in the 1980s, it was said that dynamic RAM chips were the crude oil of the U.S. industries. But what was happening is the Japanese were shipping products to the U.S. That were invented in the U.S., but Japanese companies figured out how to get high quality. And what happened here is that all of a sudden U.S. companies got really upset that they were inventing stuff, but it was being shipped over from Japan, and Japan was making all the money because they figured out how to make things in low cost and high volume. So what happened is large companies basically lobbied Congress to change the laws, which became very strong. So basically, a new Court of Appeals happened in the 1980s, early 1990s, and basically patents became stronger. So the patent owners could spend more time, enforcing their patents and going from 15 maybe to 80% in overall wins for patent litigation. This was all really good news. And then what happened is the dot-com era happened, and all of a sudden these large companies recognized that so many large companies were funded that went out of business, but they all had patents. So the small companies started litigating against large companies. As a matter of fact, investors who own those small companies that went out of business, the investors started suing large companies. And all of a sudden, there was a huge amount of litigation. And so from 2010 to 2019, this became, a huge problem until the American Invent Act in 2012 with Obama, who basically said that, patents were basically a negative for innovation. And this keeps going on from 2012 to now 2025. And what we found out is that John Squires, who's the new patent commissioner, has basically come against inter partes review. Inter partes review allowed, through the Obama administration, that any patent that was valid could be invalidated if prior art could be found. And truly that happened. 80% of the patents in the patent system were invalidated by inter partes review, and this really weakened the teeth of litigation. John Squires changed all that because the patent commissioner can, with just on a daily level, for no reason at all, say that, we should not be trying to invalidate patents. And there's a number of reasons why, one being that foreign actors started to use this system to weaken the patent system. And so basically the new administration decided to get rid of inter partes review. So this is sort of the state of play, right, of patents, all the way from the guilds to today. But as of last week or the week before this podcast, all of a sudden patents are becoming much more valuable because inter partes reviews will not be allowed as much as in the past. Let's shift to topic number 2, generic methods for IP value. It turns out that, one way to get a higher value is to build a larger portfolio. And so that's what happened. Lots of companies developed larger portfolios. The idea being that if you didn't violate one patent, I could find another patent that you violated. Being part of IBM as the top inventor at one point and also running the IBM patent factory, we started licensing. We went from 20 million to several billion a year in IP licensing, but we had an enormous portfolio of 35,000 patents. Another generic method for IP value was that you would patent things, but you'd also hold some information back as trade secrets. Here, so you're combining patents with trade secrets, so you disclose the ownership, but you might hide exactly how you're doing it. Of course, there's this best mode requirement that says you have to give the best mode, but many times there's all sorts of invention that has 8 or 9 or 10 step methods. You might only file a patent on 5 of the method steps and keep trade secret the other 3 method steps. Another thing is that you started to have more value for patents by designing patents as an asset for licensing, designing claim sets that were more broad. Another generic method you could use to change the value of IP is that you would make patents much more enforceable by making them more specific. Another generic method you could use for IP value is to do anything you could to get a patent because it was bragging rights, because you could use it for marketing. You could use it to stop copycats. You could use it to raise money. So that the world that I lived in from about 1998 to today is we've been using patent value for 6 of the different ways of making money: transactional value, stock value, etc. So patents became a way, a perceived value of creating more value by doing ways, not just litigation, but also to find ways to use patents for value in different ways. And then another way to make sort of patents more valuable was to invent around your own patents. So you had your patent, but you invented around it. So if someone tried to design around you, you'd catch them in the invent around. And another thing you'd do to create more value in patents is to do valuation. That you'd really get a formal IP valuation to figure out what the value of the patent was worth and use that in a licensing negotiation, a sale, or M&A negotiation. Today, in fact, my firm does 2 or 3 patent valuations for that reason. And then what happens is that in order to get more of a value for patents, some companies move to develop an improved monetization process. For many years, I created and ran the IP Capital Licensing Company. We have methodologies to basically help us monetize patents. And there's a whole bunch of workflow there in order to find the companies, find out who in the company, to find out what the value is, talk about how the story could be, say what the hook could be, etc. So there's all sorts of ways to try to create value in a story, in a monetization process. Another way to have generic methods to improve value is to develop an IP story. I just prior to this podcast came from a client where we developed an IP story. We were helping them understand the business, the market, the product, the technology, the inventions, and the IP, and tell that story where the IP is connected to the business value of the entity that wants to see the value of the patents. And then finally, now we have AI helping us enable these IP stories. So things are going faster and cheaper. So there's a whole series of ways to improve the generic value of IP. This is important because we first talk about the first topic about the patent system and how value got changed with events. But now there's generic ways to improve the value of your own IP position. But we got to dig in. And so in topic number 3 and topic number 4, we're going to talk about the generic pressure caused by litigation. And then we're going to talk about how the inter partes relief and the administration of the inter partes review has affected us. So stay tuned for the generic pressure of litigation and what that does, and then how the IPR relief has come in to change a lot of that. So let's talk about topic number 3, the generic pressure caused by litigation. It turns out that plaintiff lawsuits against a defendant is a shock event. In other words, the whole company tends to get wrapped around what's going to happen in this litigation. Is my product going to be stopped? Am I going to have to write a big check? Am I going to have to go to court? It's a real attention grabber. So any mid-sized or small company that gets sued through patent infringement, it's really disruptive. Another thing is, another generic pressure caused by litigation is that basically it allows the plaintiff to issue all sorts of subpoenas to get information. Sometimes, in fact, companies are suing other companies for patent litigation just to figure out what the company's been doing on a product or technology direction. It's an information gathering ploy. Another generic pressure by litigation is that litigation financing has been around for plaintiffs quite a bit. Now what happens is a third party will actually fund the development of litigation. And that's a pressure because with good patents, you don't necessarily need the money to sue a company. You could actually do it and have it backed by an investor who's doing it from a pure cost and profit center. Another thing about the generic pressure caused by litigation is that we talked about the histories of the 2000s to 2022 timeframe. Here, there was a large litigation volume while these reforms are in with the inter partes review, which was being allowed. This provides sort of an uncertainty in defense costs, favoring large defendants, because this pressure of litigation could be defeated quite easily with the inter partes review at a small cost. But what happened is another generic pressure caused by litigation is that companies became more sophisticated. Plaintiffs became more sophisticated. They started to have the use of continuations, large patent families, and coordinated assertion strategies between themselves as one plaintiff and even other plaintiffs coming together. So this became part of what was called non-practicing entities, that a company that didn't have products could sue you because they had patents, and therefore limited liability companies could just buy patents to sue other companies just to make money. And there was no counter assertion at all. And that was a generic pressure of litigation. Another thing is that in order to have a litigation, you need to have standing or ownership. And therefore, one of the new pressures that came on the patent system for litigation is you really had to have control over your inventors and assignments and all sorts of things that are core to a litigation strategy. And so you had to have that right in order to really do the litigation strategy. Another thing that caused pressure for litigation is venue shopping. That a company, when they want to sue you, could actually figure out what venue to sue you in. It means they would have to have a product in that state. So if they wanted to go to Texas, they had to have products being sold in Texas or through the internet in Texas to actually go to Texas. Well, why would you want to go to Texas? Well, back in the day, there was a lot of judges that were really partial to, plaintiffs suing. And so you venue shop. And so some companies basically venue shop is adding another pressure for litigation. Another pressure for litigation was that there was this inter partes review pressure. You see, plaintiffs faced real pressure that when they tried to sue somebody, the defendant could use the inter partes review to invalidate the patent. And this was something that really happened from 2012 on until today as a real pressure for litigation. So companies tended not to litigate. Another pressure is that if you get past the inter partes review, there's a real pressure that you're going to have to pay markman costs to defend yourself. So the defendants are actually forced to pay $250,000, $500,000 to get through the markman, and they may have to pay many millions of dollars for litigation. So this generic pressure caused by litigation has been something set up with the inter partes review, has been really vital to stopping patent litigation. So even though patent litigation has lots of pressure that I just mentioned, it's mitigated by the inter partes review, meaning I can invalidate your patents. And clearly, 80% of the inter partes reviews that were done in this last 10-year period, 80% were invalidated. It might go to show us that the quality of patents are, probably not as high because the prior art searches, were such that a company could always find some prior art that wasn't found by the patent holder or by the examiner. So there's a lot of pressure caused by litigation, of which the inter partes review basically eliminated that pressure. But now the key point, and the key point as to why I even did this podcast, that it turned out that in October 17, 2025, John Squires became the commissioner of the Patent Office. Now, John is actually a friend of mine and my family's. But basically, the inter partes review was something that John Squires was able to, as a commissioner, to basically institute that he had the authority to waive the inter partes review, challenging the PTAB organization to not fill its own docket. So now, instead, the panel could freely set its own docket. The base commissioner can do that and has waived some of the IPRs. This sends shockwaves to defendants who were going to rely on this inter partes review. The next thing is that blocking IPRs after court validation, one proposal rule is that these, if it's already claimed and already been upheld in court, you can't have duplicative validity checks, meaning if it's already been held valid, you can't then go and invalidate it again if it's already been through a court system. So this is another strength of the patent holder. Another thing is that IPR relief in the administration is you could coordinate district court and timing. So another reform would deny the inter partes review when district court's litigation will finish first, preventing the gamesmanship on the timing. So in this way, you might try to do something locally to have a local judge rule on validity or invalidity, and this way to have the patent office judge the inter partes review quickly and not allow it helps the patent owner. There's a lot of challenges that go to patents, and here what we have is that Squire proposes forcing petitioners to limit parallel petitions and serial attacks. So there used to be a strategy of death by a thousand cuts, and now what's happening is that Squires is proposing to force petitioners to limit parallel petitions, so he can eliminate the inter partes review based upon serial participation. Another thing is that the inter partes relief is going to restore reliability for issued patents. Sort of the sacred idea of a patent is it's valid, and it's valid until it becomes invalid. The inter partes review kind of said even if it's valid, we can invalidate it. And with this new direction of the patent office, that's going to become less of a problem now. That if it's valid, it's going to stay valid, versus if it's valid, it's easy to invalidate it. And then the administration believes that, having repeatable IPRs has been something that they want to eliminate. They have found in certain industries, for instance, that there's been certain bad actors that have used the inter partes review to weaken the patent system. Companies like Huawei and DJI and ByteDance have literally 10% of all the IPR reviews have been by them. So a new part of the administration is to find a way to not have IPR reviews, because this was something that foreign bad actors really took advantage of. So another reason for inter partes review elimination by the patent commissioner is not only to create patents that are stronger and more valid, changing all the gamesmanship, changing the rules, but also eliminating the foreign bad actors here. So basically the IPR relief comes as a real change, and basically it's going to help make patents more stronger. It's going to be better for national security, and it's going to be a stronger and more easy policy to understand. So this sets up the situation now. So what we want to do is sort of start thinking about the sort of future of this. So next we're going to dive into new thinking for patent owners, where the failing IPR basically makes patents very strong. We're also going to talk about, since there's new thinking for patent owners to take advantage of this new direction, what does this mean to AI? Does AI now play an even deeper role with stronger patents? So hold on, and we'll get right back to you on these two new exciting topics. So let's get into topic number 5, new thinking for patent owners. Basically, in this section, we want to talk about, given the new IPR changes, that is, the patents are now stronger, what does this actually mean for patent owners? Well, the first thing is the patents are more likely to give a return now because the IPR is gone, or at least not going to be effective. The second thing is that the baseline cost of defense is going to go way up. Basically, by not having an IPR, invalidation, you're going to have to spend 250 to 500,000 for the markman, likely 2 or 3 million to basically defend the patent, or to defend against the patent. And then basically, if you have to pay a loss, you have to pay that loss and likely royalties. Another thing is that a patent owner, the win rates should be higher. Patent holders win roughly half the cases, and they do so with damages. So now, in fact, for defendants, that's going to be a much higher hurdle, that they're going to have to start thinking that there's real money in this. And so they might start to recognize they have to change and settle more. Another thinking of patent owners is that since the average settlement's around $8 million, basically, the cost of defense has to be added to this and the average settlement. So this means that there's going to be lots more money to be paid out to the plaintiffs. And again, that has to be calculated by new patent owners or patent owners that already have patents, because their patents become stronger and more valuable. Another thing is plaintiffs typically spend 2 to 4 million just to litigate, and they would not think about doing that given the risk of the IPR to knock them out, they want to go forward with that. But now I think without the IPR, that more and more patent owners will be ready to risk the 2 to 4 million to go all the way. A new thinking also for patent owners is that there's a high settlement frequency. 90% of the cases that are litigated get settled out of court. So that now means that there's a higher probability for plaintiffs to exercise their patents to get towards a settlement. And sometimes settlements happen right after the markman. So I think this is yet again some new thinking. Another new thinking is there's an enormous upside to royalties. And inter partes review kind of knocked out a huge percentage of these lawsuits this way. But now more will go through, and therefore royalties, will be a big issue now for defendants, and they'll have to think about that. So plaintiffs will have to start recognizing that they have more money to be made. Another thing is that this unlocks licensing because licensing of intellectual property was always stopped by someone saying, I don't really care, sue me anyway. Well, if that thinking goes away, licensing should open way up, way up. Another thing is that litigation financing basically has waned over the last number of years. And because of inter partes reviews being basically eliminated, I think that there's going to be more hedge funds available to do litigation financing. And finally, another new thinking is that, when we look at the posture of modern owners, given the economics, the plaintiffs can sue not just to stop, others, but they can stop copycats, etc. So I think this creates a new sort of way of looking at patents that patents can really be used to stop copycats. And also by turning these patents into bigger and bigger assets, they can scale. Let's jump to topic number 6, which is basically to talk about the future of litigation with AI. First of all, basically, AI compresses the patent lifecycle. It can help do the searching, draft the patent applications, predict examiner actions. So that's all going to help the patent owner. Another thing is the future of litigation means that AI can algorithmically kind of optimize litigation. It can take a look at, sort of all the millions of documents that could be involved in prior art. Think about all the documents involved in court cases, simulate jury trials and all the rest. So AI can really help to make litigation better or more predictive. Another thing is that the future of litigation with AI is that basically strategies may shift to be more predictive and forecasting versus, maybe thinking about when you're trying to sue somebody, thinking about all the reasons that would stop you from doing that. Now AI can give you all the reasons that might help you win, and the fact that it's more economical, you might decide to do that more. It may be true that AI will be much more involved in litigation, but much more involved in patent examination and much more involved in prior art. So therefore, patents should get stronger. Once again, this new thinking can help litigation. Also, I think that what's going to happen is you're going to have sort of AI will continuously scan product releases, etc. So you can have AI automatically figure out how and decide when to trigger a patent litigation. That couldn't be done in the past. Another thing that AI can do in litigation is it can automatically create damages models. So you can very quickly size whether or not, you should be able to have enough damages to go forward with the lawsuit. Once again, this is really good for the future of litigation. Also, the sort of IP game board, it's using AI to help you kind of game the litigation, the plaintiff and defendant, and the actions on each side. That AI can help you see through the litigation more clearly, so you might be more apt to want to do this. Another thing is it'll be automation and discovery. So the AI can actually help in the discovery process, extracting information and asking for things that maybe you might not have asked for in litigation. And then finally, basically, we start to look at the future of litigation where judicial and funding predictions that AI will be able to predict judicial behavior. It's already happening now, but in the future, it ought to be more and more of, prediction of what's going to happen. So you add it all up, that AI in the future of litigation is going to be extremely high. And therefore, with the IPRs being, not effective anymore, expect more litigation, expect it to be more AI-based, and expect it to be more, predictable and profitable. So there we have it. Let's kind of wrap up. In topic number 1, we talked about a short history of IP value. We went everywhere from across 700 years, from guilds all the way to the current, place. Talked about the Court of Federal Appeals being stronger in the 80s. We talked about Japan and, shipping products to the U.S. and the U.S. needing to strengthen the patent laws to actually defend against that. talk about large companies that basically made the patent laws, weaker, uh, but now they're trying to make it stronger again. And the quote of the inter partes review would suggest that now patents are going to be much stronger. Large companies might not want that, and so be expecting lobbying to try to weaken it again. We talked about generic methods of making IP more valuable, from building large portfolios, inventing around your portfolio, taking advantage of trade secrets, how to have license registering claims, inventing around continuations and things like that. We found that even AI-enabled monetization systems can help us in this generic method evaluation. But then we talked about the pressure of litigation in topic number 3. We saw how today's plaintiffs really could weaponize by making a shock event, by disrupting a company, or by using it for discovery, or using third-party litigation to help them. We also talked about this sort of continuation-driven assertion that basically they change their claims all the way through the assertion through continuations. And we also talked about how AI can be, used with judges to improve the understanding of where patent litigation is going to go. All these things created pressure that litigation was 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 a powerful thing, but it wasn't used that much because of the IPR reviews. Today, in fact, it's not going to happen because IPR reviews are going to be eliminated. And then we actually talked about the topic number 4, the IP relief and administration, with John Squires coming in and sort of now claiming that IPRs are basically his authority to, on a daily basis, sign off of not allowing IPRs to go forward. This is a real shift, and it happened last week or two. So the pendulum kind of really swung back to make patents much more valuable for the patent owners, which then sets up topic number 5, the thinking of patent owners. With the ability of not having IPRs in the way, plaintiffs will get stronger, that there'll be more and more of them, and the probability of success is going to be even higher. This then opens up things for licensing as well, and all those things that have to do with patent value. So the pendulum not only is going to swing, but it's going to gear towards more litigation and more value to the patent owners. And finally, we talked about in topic number 6, the future of litigation, adding AI. We're going to be using AI to compress the patent lifecycle, to help it with getting things enabled, to do better prior art searches, to algorithmically figure out whether litigation should occur or not. Sort of doing that virtually before you do it, directly. It can be predictive. It can generate all sorts of harder to invalidate portfolios. It can give you real-time, infringement analysis. It can scan products to see if there's any new product out there that is violating your patent and automatically trigger sort of a litigation direction. And so for all these dynamic changes in modeling and all that stuff eventually gets to the point that AI can help make litigation happen. Now, we haven't talked about AI being also used on the defense side, but certainly AI used for litigation in the future is going to be another thing that's going to drive litigation. So to summarize, the patent pendulum has shifted and will continue to shift. The inter partes review going away the last couple of weeks is going to play out, and it's going to show that there'll be more value for patent owners, and also AI is going to be helping that value be recognized. So this is John Cronin, Invent Anything. If you like what you've heard, please subscribe and join us at Inventors at Work.